CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Mr. King, Ms. Brady, Ms. Nelson, Ms. Spengler, and Ms. Higgs. And the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Mr. Essen, and Ms. Stitch McGuire. We are outside the presence of the jury. Is there anything we need to talk about before I bring the jury in on behalf of the people?
Put on the record, Judge, I did give your clerk a copy of our proposed hot mail exhibit after the court's ruling yesterday.
Yes, this morning, right? And I haven't had time to go through it. So if I need to do that, then I'll take another break and I'll go through it.
I understand. We just gave it to you this morning. I also gave a copy to the defense as well. Okay.
Are you intending to introduce it first thing this morning?
First thing, Judge, I think it'll be the second to last witness. So probably later this morning, depending on how the morning goes.
Maybe we'll get started and then take a break and I can review it at that point, and then the defense can review their copy as well. All right, is there anything on behalf of the defense?
Clear.
Okay, let's bring the jury in, please. Please be seated. Good morning, everyone. The record should reflect that the jury is now in the courtroom. How's everyone doing? Good. It's good to have you back. Ms. Stitch McGuire, you may call your next witness.
Thank you, Your Honor. Petra Hogan.
Good morning. Could I have you raise your right hand so that I can administer an oath? Do you solemnly swear or affirm under penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Okay, please be seated. Could you please turn the microphone toward you? There you go. And then please tell us your name and spell your first, middle, and last names.
Petra Hogan.
or Petra Ann Hogan, and that's spelled PetraannehOgan.
Ms. Teachmawire, you may proceed.
Thank you, Your Honor. Were you at the Century 16 movie theater in Aurora, Colorado on July 19th and July 20th of 2012?
Yes.
Who were you going to the movies with that night?
I was with my friends Ethan Rodriguez Torrent and the friend that he had brought with him, Stephen Barton.
How did you know both of those gentlemen?
I met Ethan in 2008 at the Horatio Alger National Scholar Convention Summit because we both received the scholarship.
Judge, at this point, I'm going to object as to relevance.
Sustained.
How are those two people visiting you that day?
They were biking across the country from the Atlantic Ocean to the Pacific, and they arrived in Denver, and I offered to let them spend the night at my house, and so they were taking me to the movie as a thank you.
What time did you arrive at the movie theater that night?
We arrived at least an hour before it started, maybe more.
What did you do when you got to the movie theater?
We went in and we found our seats pretty easily, and
Where did you find your seats in the theater?
we were sitting in the in the stadium seating, we were in the center, about half to 2/3 of the way up.
And if I may approach the witness with what's been marked for identification as People's Exhibit 1256.
Yes.
Ms. Hogan, I'm going to ask you to please write on that diagram a P for Petra, an S for Stephen, and an E for Ethan on the seats that you were seated in that night. If you could also please write your full name and today's date, which is June 19th of 2015.
I just wrote the wrong date.
That's okay.
accidentally.
You can write the new date. I said the wrong date, so of course you were going to write the wrong date. May I approach, Your Honor?
You may.
Your Honor, this time I'd move for the admission of People's Exhibit 1256.
I have no objection to 1256.
Without objection, P-TR-1256 is admitted.
Thank you, and with the court's permission, I would ask Ms. Hogan to be able to grab the cordless microphone and meet me at the 3D model.
Yes.
Thank you. All right, could you turn that on? Good, great. If you could please show the jury where you were seated that night.
Sure. We were right about here in the theater.
Could you please tell the jury where you were seated and where Mr. Rodriguez-Torrent was seated and where Mr. Barton was seated?
I was in between them, so I was about here. Ethan was on my right, and Stephen was on my left.
Please tell the jury about what happened in the movie theater that night.
I'd had a long day of work, and I was quite tired. And so, as the previews started, I started drifting to sleep. And I couldn't tell you how much time had passed, but I immediately woke up, it came to when I heard gunfire and saw flashes at the front of the theater,
And could you show the jury where you saw the flashes?
right here.
That front upper right part of the theater, the screen's right up.
I immediately knew that I was in a shooting and that there was a possibility of being shot. I knew there was the possibility of getting shot. And so, because we were in the middle of a row and the theater was packed, there was nowhere to go. And so, I remember putting my left arm on the seat in front of me as I began to get down behind the seats. And then I blacked out.
What's the next thing you remember after you blacked out that first time?
I remember coming to in face down behind the seats in a pool of sticky, thick liquid.
Could you hear anything in the theater at that point when you came to?
I could continue to hear gunfire, and I could hear screaming and running.
Could you see anything at that point in time?
No.
Please tell the jury about the next thing you remember.
I remember feeling my throat was burning and itchy, and I couldn't breathe through my nose, and I felt like I couldn't breathe at all. And so, even though I continued to hear the gunfire, I was trying to stand up because I couldn't breathe, and I thought that would help me. But Ethan realized what I was trying to do and climbed on top of me to keep me down behind the seats. And I remember after stopping to fight with Ethan to get up, I remember thinking, yeah, it's probably not a good idea to stand up while there's gunfire going on. And then I blacked out again.
What's the next thing you remember after you came to the second time?
The theater was quiet, and Ethan asked if I could get out of the theater, if I could crawl to the end of the row. And I said, I think I can. And so we army crawled to the end of the row.
Can you show the jury what you did, please?
This direction. So I was in front of Stephen, or excuse me, I was in front of Ethan in our army crawl. And when I got to the end of the row, I stood up, which was a little difficult for me. And I didn't realize there was an exit at the back of the theater. So I began walking down the steps of the theater. That's when I saw a body in a seat at the end of the row in one of these lower rows.
What did you do after you saw that body?
Well, the first thought that crossed my mind was there anything I could do to help that person? But the body was just sitting.
At some point in time, did you come to contact with Mr. Rodriguez Torrent again?
Yes. When he stood up at the end of the row, he called to me to come with him to exit out the back of the theater because we didn't know how many people had been firing weapons. We didn't know where they were. And so we walked up the stairs to the back of the theater, which was hard for me to do, and I didn't know why at the time. And we walked out of the exit, and Ethan continued to help me down the stairs, out the back of the theater, into the lobby. And then we walked out of the theater, and I was increasingly having difficulty walking, and Ethan set me down on a median outside the theater and said, "Wait here, I'm gonna go find an ambulance." And at that point, I didn't know what was going on, and I saw a figure that frightened me, and so I thought, I just need to get out of here because I need to be there for my mother.
Okay, thank you, Your Honor. At this time, Ms. Hogan, I don't have any further questions for you at this model. I'm going to ask that you retake the witness stand. Thank you. Ms. Hogan, were you transported for medical treatment?
Yes. A man named Daryl Wilmoth and another man who I don't know his name saw me on the median and carried me to the ambulance because at that point I was not really able to walk.
Was there anyone else in the ambulance when you were transported to the hospital?
No, it was just me, and I remember when I got into the ambulance, I finally felt safe, and I began crying uncontrollably, and I couldn't stop, and I didn't stop until I was in the emergency room, and they gave me meds.
Were you in any pain when you were in the ambulance?
Extreme pain.
Where were you hurting?
It was my left arm, my left forearm. It felt like I believed at the time that my arm must have been broken because there was pain emanating from a single location. And at the same time, it felt like my arm was on fire from the inside out.
What hospital were you taken to?
I was taken to the Aurora Medical Center.
How many days in total did you spend at the hospital?
I spent 20 days.
Was that at 2 different hospitals?
Yes, it was.
Okay, please tell the jury what hospitals those were.
I was at the Aurora Medical Center, and then I was at the Spalding Rehabilitation Hospital.
Please tell the jury about what injuries you sustained as a result of the shooting.
I was shot 3 times. I had 1 pellet in my forearm. I had 1 pellet that passed through my, my bicep, tricep, outside of my arm area. And then I had another pellet that entered my nose, traveled through my brain, and stopped at the back of my skull.
How many surgeries did you have, Ms. Hogan?
I had 3.
Right. What was the first surgery for?
The first surgery was brain surgery to remove the pellet from the back of my skull. They had to remove part of my skull to
Objection, Judge,
remove the
403.
Overruled.
You can tell the jury about what they had to do in that surgery.
They had to remove part of my skull to retrieve the pellet that had lodged itself at the back of my skull.
What was the second surgery for?
The second surgery was to reconstruct my sinuses because the pellet blasted through my sinuses as it entered my brain.
What was the third surgery for?
The third surgery was to remove the pellet in my forearm.
Your Honor, if I may approach the witness with what's been marked as People's Exhibits 2035, 2036, and 2668.
Yes.
Ms. Hogan, do these pictures fairly and accurately represent the injuries you sustained as a result of the shooting on July 20th of 2012?
They do.
Your Honor, at this time, I'd move for the admission of People's Exhibits 2035, 2036, and 2668.
Is there any objection, Mr. King?
Judge, I would have no additional objection to 2036, and I have no objection to 2668. I would object to 2035 as cumulative under Rule 403.
All right, give me just a moment, please.
Okay. 2035 and 36 were subject to the court's order previously.
That's correct. Can I see the photographs, please? Okay, P-TR-2668 is admitted without objection. P-TR 2035 and 2036 were subject to amended order 98 or D98B. And so for those reasons, it is admissible. The question then is whether P-TR-2035 is cumulative. And I find that it is. So under Rule 403, I'm going to sustain the objection that has been made now by Mr. King with respect to P-TR-2035 under Rule 403.
May we approach, Your Honor?
You may. Okay, my ruling stands.
Your Honor, I would request to publish at this time.
Yes, you may publish 2668 and 2036. Both of those are admitted.
If I could please have 2036. Ms. Hogan, if you could please describe for the jury what we see in this photograph. And there's a mouse up there that doesn't work very well, but you could try to point out your injuries for the jury.
This right here is the entrance for the pellet in the forearm. This is the through and through, where there was no pellet lodged in, but this was the entrance, and this was the exit. And then it's hard to see, but the pellet entered my nose right about here.
Thank you. If I could please have 2668. Could you show the jury on this photograph where your injury was?
So the pellet entered right here.
I have no further questions for, oh, sorry, I do have one more question, Your Honor. Ms. Hogan, could you please tell the jury about the lasting injuries that you have as a result of the shooting?
The lasting injuries that I continue to have are all cognitive in nature. At the Spalding Rehabilitation Center, I was diagnosed with aphasia, which is can present, and in my case, presents as difficulty.
Judge, I'm going to object at this point under Rule 403.
All right, the objection is overruled. This goes to the permanent nature of the injuries.
Thank you, Your Honor. You can tell the jury what aphasia is.
Presents itself as difficulty sometimes finding words, constructing ideas, clarity of thought sometimes.
Thank you very much, Ms. Hogan. I don't have any other further questions for you.
Mr. King, do you have any cross-examination?
No, I do not, thank you.
All right, and the jury does not appear to have any questions for Ms. Hogan. Ms. Hogan, thank you. May she be released from her subpoena?
Please, thank you, Your
Is there
Honor.
any objection?
Without objection.
All right, thank you, Ms. Hogan. Call your next witness, please.
Hillary Allen, please.
Ms. Stitch McGuire, do you want to retrieve this? Thank you.
Your Honor, could we request that the model be moved unless it's going to be used with this witness?
Yes, that request is granted. Good morning. Can you raise your right hand for me, please? Do you solemnly swear or affirm on the penalty of law that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? All right, please be seated. Could you please tell us your full name and spell your first, middle, and last names?
It's Hillary Faye Allen, Hillary Fayallen.
Mr. Brockler, you may proceed.
Thank you, Your Honor. Miss, would you please tell us what you do for a living?
I'm a graduate student at the moment
Where?
at UC Denver, in the Anschutz Medical Campus.
In what specific area?
Neuroscience?
I want you to take a look to your right here. And do you recognize the defendant in the beard and the mustache and the glasses seated over here?
Mm-hmm.
Tell us how you know him.
Is that a yes? I'm sorry.
Yes, that's a yes.
Thank you, Your Honor. Tell us how you know him.
He was a classmate of mine in the first year program of the neuroscience.
What's his name?
James Holmes.
When did you first meet the defendant?
At recruitment weekend, I believe.
That in 2011.
February. I'm not sure the exact date.
Do you remember having much interaction with the defendant back in February of 2011?
No.
When do you first recall sort of interacting in any meaningful way with the defendant?
Probably our first year once we were actually starting the school year. We had classes every day, core classes from 8 to noon, and then our own neuroscience classes.
Now, we have seen exhibits of class schedules, and we know there are core classes, and then there are a couple of electives. Because you were one of the neuroscience students along with the defendant, would you have seen him in class every day throughout the course of that first year?
Yes,
Okay.
roughly.
Now, you had different labs?
Mm-hmm.
Is that yes?
Yes.
I'm sorry, and the words matter because...
Sorry, yes.
That's okay. Tell me about the first observations that you had of the defendant back when you first started to have class with him in, did you say August or September?
August, I believe, is when the classes started.
Okay, of 2011?
Mm-hmm.
Thank you. Tell us.
Tell you
What were your
what?
first observations of the defendant? What did you observe about him?
It's hard to say. I mean, we're in class. I had little interaction in the actual classroom setting. However, I mean, we're scientists, so I mean, we're not the most talkative people. So, I mean, I don't know how to.
Was he quiet?
Yes.
All right. Early on, did you and others in the neuroscience program try to get together and socialize, or did you all just keep your separate lanes?
No, we had a lot of that at the very beginning, and we had certain groups that would study together or something like this. But James was not a part of that. I think he had his own. The first semester, I think he had his own set of friends. It wasn't until the second semester that I had more, interaction with him.
Now, that first semester, when you said he had sort of his own set of friends, do you know their names?
I know at least one of them, Gargi. I would see them, having coffee together, things like this. So I had little interaction with him outside of the actual classroom.
Okay, no conversations inside the hallway or before or after class?
A few. It was just more kind of an awkward hello or, something like that.
Tell us why it was awkward.
Just because I'm very friendly, and normally if I see someone I recognize, I would strike a conversation with them and say hello. He would keep his eyes down, but I thought that was just because he was shy or, not wanting to talk. So.
Did you find that unusual for the other guy scientists that you interacted with?
No, I mean I've encountered that before.
So you had the opportunity then to observe the defendant in each of his 3 presentations from his lab rotations? Mm-hmm. Is that yes?
Yes.
Right.
Yeah.
And describe them for us, the presentations.
So yeah, we were required to go to all the presentations. There's 6 neuroscience students. They were well prepared. They were very different from the interactions, the social interactions that I had with him. He seemed very confident in his presentations, I had to psych myself up for those presentations. It was quite an intimidating thing to do. But yeah, I thought they were well prepared. I mean, he seemed very intelligent, and at least the first 2 presentations, seems like he had a good rotation. I mean, he would tell these kind of like silly jokes during the presentations, which some might interpret as professionally like just inappropriate, but I mean, it's just kind of his style. But it was a lot different than what I knew of him just from like walking by in the hallway and saying hello. He just seemed a lot more confident up giving his presentations.
Was that true with each of the 3 presentations you saw across the year?
Yes.
Now, at some point during the academic year, that first year, did you interact with him more over a certain rotation that you wanted to do?
Yeah, so initially, I think I struck up conversations with him, maybe like outside of class, because the students would talk to one another to figure out which rotations they were doing and which professors they liked or didn't like. And I wanted to rotate in the lab that James was rotating in, so...
Which lab was that? I'm sorry to cut you off. Which lab was that, ma'am?
Achim Klug. That's who I wanted to rotate. And then later on, it was Mark Delacqua. Those are the labs I wanted, and was trying to get his judge of what he thought about the research or, that lab environment. But he beat me to it. Like, I never got to rotate in Nahum Klug's lab. I did get to rotate in Mark Delacqua's.
Now, in those conversations that you would have with the defendant about getting some sort of background or intel on these labs, how was he in talking with you?
Via text, it was okay. It was fine. It was, like, pretty social.
How about in person?
We did. I mean, it wasn't as kind of naturally flowing. We had a few interactions, like longer conversations, talking in person, but most of it was via text.
Was he different in person than he was in writing?
I would just think it's kind of like more like he was when he gave a presentation. He was more confident and more natural and more. I think that's common with scientists. Like, you have more time to think and like write out something than, I don't know.
You had an opportunity to observe him in class. Describe for us how he was in class. What would he do or not do?
I remember him never taking notes, and that kind of like made me mad because I was like, writing down everything I could to try to get a grasp on the material, and it seemed like he really had no problem remembering the material, or maybe it was because it was review for him. For me, all the material was new, so I would take notes, and that's just how I learned. But I remember he just wouldn't take notes, and he seemed to do fine.
How would he sit in class? Would he seem attentive?
Yes and no. Mostly, it seemed like he wasn't paying attention, but then, when a professor would ask him a question, he seemed to do fine, or if he had like an assignment to do, it was okay. But it seemed maybe that he wasn't paying attention, but I guess he was.
But he answered all the questions the professors called on him for?
For the most part, yeah.
And as far as you know, got all the assignments done?
Yeah.
At some point, you guys have a mock grant proposal writing class? Mm-hmm. Is that true?
Mm-hmm. Yes, it was true.
Thank you. And during the course of that course, did you look at each other's work and pass it around and do stuff like that?
So this course is basically, it helps mimic a real peer review, they call it in academia. So like when you submit a grant, other professors from, different universities would read your grant and submit a score to the NIH to, like, on these private committees. So it's called peer review. So we were trying to mimic that in our class. And so, yeah, we would basically pass around our grants and judge them. So I probably read 2 or 3 different grants from other students.
What was your perception of the defendants?
It was really well written and good ideas, and I was actually quite impressed. It was the best one that I read.
And in fact, it was so good, what did you do with it?
I don't remember.
Did you show it to your dad?
I'm going to object to leading and relevance.
Sustain to leading?
Do you remember if you did anything with it or showed it to anybody else?
Judge, I'm going to object to relevance.
Hold on a second.
Can we approach, actually?
Yes, why don't you approach? right, the objection's overruled.
I'm going to show you something here that's going to talk a lot about that thing that we were talking about. So before I do that, though, let me set the stage for this.
Okay.
Did you, prior to April 9th, 2012, did you engage in any sort of phone calls or outside of class socialization with the defendant?
No.
Did you ever exchange phone numbers or texts or anything like that?
No.
On April 9th, 2012, did you receive a text that later on turned out to be from the defendant?
Yes.
After you were contacted in this case, did law enforcement come and say, we'd like to get all the texts you exchanged with the defendant?
I voluntarily provided them.
And have you had a chance to review those in
Yes.
the past? And by the way, did you delete any of the text, or is what I'm about to show you everything that you had?
I didn't because, I thought it was important. So, they took pictures. I saw them, take pictures. And then supposedly they downloaded, the information from my phone. But I kept it on my phone until I got a new cell phone.
Okay. May I approach the witness, Your Honor?
Yes.
Yeah.
I think so too.
You may. What exhibit is this?
This is going to be People's Exhibit 1046.
Thank you.
Miss, would you take a look at that, please, and tell me, are those the text messages that you had on your phone that were exchanged between you and the defendant between between exactly April 9th and July 8th of 2012?
Yes.
One thing I want to clarify on the record, would you look at page on the bottom right-hand corner, 1047, oops, scratch that, 10468 and 10469. Are those
Yes.
duplicates?
Yes, they are.
Yeah, other than that, just flip through that again and make sure, are those a fair and accurate copy of all the text that you exchanged with the defendant?
Yes. Looks like it's all here.
Your Honor, I'd move for the admission of People's Exhibit 1046 into evidence.
No objection.
All right, without objection, P-TR-1046 is admitted and may be published.
With the permission of the court, what I'd like to do, Miss, is I'd like to go through and have you put in context some of the conversations that are going on, and then I'd like to publish to the jury the individual copies of the text messages. Is that okay, Your Honor?
That's okay.
All right. Ma'am, would you put up 10461, please? Can you talk us through, is this the very first text you received from the defendant?
Yes.
Now, do you remember or know how he got your cell phone number?
No.
And is that captured in your response to the first text that you got?
Yeah.
All right. Now, this next part at the bottom that starts off and by the way, I should ask this, who is blue and who is gray?
Gray is James. I'm in blue.
Okay. The gray part at the bottom there, right under April 9th, 2012 at 4:39 p.m., sick of Delacqua yet, he would always linger way too long. Put that in context for us. What is that a reference to?
So I was in the Delacqua lab, so it was the third rotation. And Delacqua, he would come in, like late in the day and just kind of hang around the lab. And it's always awkward. Like if you want to leave and your professor's there, it's like your boss is there. You don't really want to just be like, hey, okay, I'm going to leave now. So,
Right.
yeah.
Okay. Ma'am, 10463, please. There's a gray part here that starts off with no bueno. He got pissed at me. What are you guys conversing about here? Talking about Delacroix.
Just how he did in the lab itself. I was trying to figure out if he liked it or not, and apparently he did not like it.
Okay. And did he ever express to you any different feelings about that second rotation?
His second rotation, any different feelings other than that he didn't like it? No, it was definitely clear that he was not going to join that lab. That Delacroix, they just didn't get along, or, yeah.
4, please, ma'am. In speaking about the rotations, down here at the bottom, and ma'am, could you blow up the bottom gray and blue part right there? Do you know what, in talking about what rotations to do, what the defendant is referencing in his gray box there?
That he wanted to join Ahim Klug's lab?
Okay, thank you. Can you go to 6, please? This is all part of the same conversation. Your blue square, tell us what you're referring to here, what you're telling the defendant.
So I was roommates with Yom Puli. He was my roommate. And I found out later that's how James got my number, because they had studied together. And so Yam was Korean, and he had another friend who I couldn't remember his name, like this other Korean guy. That's who I'm referring to. And I was telling him that I was sure which lab I was going to join, and that was my second rotation.
And so by April 9th, when you're having this conversation, you'd already had confirmation that you'd had a lab for the remainder of your PhD program?
Mm-hmm.
Is that yes?
Yes.
Sorry. All right, can you please go to 8, ma'am, and the bottom of that? Now, this is now April 23rd. It looks like there's been a break in the conversation since the 9th. What's going on here?
Okay, it's kind of awkward, but so it's summertime, like I'm wearing shorts in class, and I remember we're in the last class, I forget exactly, I think it's developmental neuroscience, maybe it's still systems, I'm not sure. One of the classes that we were in, we were done with core at this time, and so Carl Fenninger, I believe, was the professor, and he's notoriously he's hard, like he's strict, and so I remember we were having this lecture, and it seemed like, James was there not taking notes, like kind of, off in his own thing. And so Carl called him out to ask a question. And I think he maybe stumbled and then answered. And then after class, I got this text. Apparently I was in shorts, and it was distracting.
Out of the blue.
Yes.
Now, in between the 9th and the 23rd, in between these text exchanges, had you had any more contact with the defendant other than seeing him in class?
No, so that's why I was a bit taken aback. I remember just kind of like laughing out loud when I received that text message, just being kind of embarrassed.
Can you take us to 14, ma'am, please? In the bottom of that, please. Can you please put into and this is from April the 25th at about 4:43 p.m., back and forth. Can you put in context for us what you're talking about here?
Talking about the third rotation that James was in, how it was going, because we were probably preparing to give our third rotation talk, and he didn't have any data, so no really analysis to do.
Is that a problem?
No, it's common actually. In a rotation, you only have 10 weeks to have a project and generate data, so it's not always uncommon to have no data. The majority of the rotation talks are background, because takes a lot to kind of introduce the topic you're discussing. So no, it's not uncommon. It happened.
This is probably a good time to ask you about, since you're a student, and we've had the professor perspective, from the student perspective, what is more important as you go through the neuroscience program, the academic classes or the lab rotations?
I would say the lab rotations. I mean, you have to pass your classes, but if you think about it, in our program, we're going to be in the lab for 5+ years, so, and the coursework is only, a year. So yeah, you have to pass it, but you also have to have a good rotation and a project to work on for the remainder of your thesis.
Now, is there a different skill set in your experience that you need to be successful in a academic classroom setting versus the laboratory setting?
Yes.
Tell us about it.
So even in the classroom, there's still more work involved than, a regular undergraduate class. There's more responsibility on the student, but still you're guided through it because you have a syllabus and the professors are giving lectures and you know what to study. In the lab, it's definitely, you have to the student has to take control over their project, and they always say, science is your baby. I mean, they say that in this is school, and it's true because you have to take care of it. You have to think about it when you're not in class. You have to think about it when you're not in lab, and it's your responsibility to drive that project forward. So if you're used to kind of someone holding your hand and walking you through what exactly you have to do, in most cases, most labs, that would be hard to, in most labs, professors are not going to do that. So
More self-initiative.
Yes.
Can we get, please, page 17, right in the middle? This is still part of the same text string, but at some point during this, is that the defendant asking you out for a hike?
Yeah.
Now, you hadn't approached him about the hike. He asked you?
Mm-hmm. Yes.
Thank you. And so there's a lot more text that goes on after this, but what ends up happening?
We go for a hike
Where did you go do that?
in Golden Gate State Park, Golden Gate Canyon State Park.
In fact, can you get us to 22, ma'am, at the top? And is that it? Is that when you solidify, hey, we're going to go on this particular date?
Yes.
All right. Talk to us about what you did on that hike, and you can take that down. Thank you.
He chose the place. Ironically, I had never been there before, and I'm from Colorado. I think that's initially why he asked me, because I like doing things outdoors. So yeah, he chose it. We decided when we were going to go, the time.
Who drove?
He did.
And did he do anything else to prepare for this hike?
Brought snacks, like Gatorade, and
How would you describe the level of preparation for this short day hike?
I mean, usually if I go hiking, I just bring like water maybe, but other people always bring snacks. I didn't think it was like over prepared, but just kind of like, all right, cool, he wants to bring snacks, that's fine.
How long were you guys hiking?
I think we went from about 1 and I had to be back by 6, so around there with the driving time and everything. So, a fair amount of time.
Who did most of the talking on the hike?
Me probably, because I'm a chatterbox.
Nonetheless, did you have decent conversations with the defendant?
Yeah.
And do you remember what you talked about this much time later?
Probably, I don't remember in particular, nothing stood out like that was weird or just out of the ordinary, just normal conversation about, what my family did, what his family did, what he saw himself doing in the future, what kind of, job, since we're, in grad school, what we're there for, and rotations probably.
Did the defendant seem to be more at ease talking with you in that setting than either in the classroom or the hallways, anything like that?
Yeah. Yeah.
And then after the hike, where did you guys go?
He just dropped me back off at my house.
Was it at all awkward at the end there?
A Well, yeah, because I didn't want it to be perceived as a date or something. So, I mean, I think he got out of his car and, we hugged or something and then said goodbye. But there's always that little awkward lingering, like, oh gosh.
Yeah. You're both sitting in the car kind of thing, that sort of
Yeah, a little bit, yeah.
lock the door?
Yeah, yeah.
Nothing like that.
Nothing like that.
Okay. Now, there was something else, by the way, that came up before you went on the hike. Did you, in these texts, and I'm referring now to page 28 at the bottom, ma'am? You told him, it looks like, that your house had been broken into. Do you remember that?
Yes, I do.
Okay. And then can you please go to 29, just the upper two-thirds, a little bit down. Okay, now, a little more down, ma'am. Thank you. Does he express to you any concerns about his own safety in any of these text messages?
No.
Has he ever, even on the hike, expressed to you any concerns about his own safety based on what you've told him?
No?
The burglary, the attempted burglary that took place at your place, were you there for it?
Yes, I was.
And can you tell us, was there ever a screen that was cut to gain access to your apartment?
Not that I remember, no, just broken glass. Like, it was in a house, so the back door was broken into.
Thank you. Can you please go to 31, ma'am? Now, this again is still before the hike, but and can you blow up that top portion? Thank you. What kind of conversations are you getting into here?
What we're going to do after we pass prelims and get into the program and choose a lab. Stay here more long term.
Had you given any thought to buying a house or anything?
No. I always wondered how grad students could actually do that on their stipend.
Okay, can you go to 42? Now, I don't want this to be awkward either, but is there more banter being initiated here by the defendant?
Yes.
Would you consider this flirtatious?
Yes.
All right. Keep going down if you would, ma'am. By the way, do you guys ever end up going out again after that initial hike?
No.
Does he, in these texts, suggest that you ought to go on another hike again?
I think there was discussion about it, yeah.
It didn't happen. Why not?
Yeah, I just got so busy and stressed out with school, honestly.
In fact, can you go to 48, ma'am, the last bottom blue part? Yeah, thank you. And that's now, we're now on May 5th. Is this sort of the last time that you have a conversation about going on a hike until well after?
Yes.
How about 49 at the bottom? It's May 8th now. What's going on here? What are you guys talking about?
Preparing for our third rotation talk.
Okay. And then can you go, ma'am, to 50, right about the middle below the blue part, or including the blue part. Thank you. So it's now June 1st.
Mm-hmm.
Are classes over by now?
Classes are over.
And you've seen that third rotation talk that the defendant gave?
Yes.
In terms of presentation, style, affect, demeanor, was there any difference between that and any of the other presentations?
No.
How about substance?
Substance, yes. It was, I mean, I knew that he had no data. Obviously, we discussed it. It was in the text messages. So that would be hard. I mean, if I was in that same position, that would be hard to prepare a talk that I had no data for. So it was apparent that it was clear that he wasn't joining that lab because the content of the talk was not there. There was really no data, no analysis. Really, it just didn't seem like he had put much effort into it.
Now, when we go to June 1st here and you ask him about studying for prelims, he gives you this answer, don't really know what to study, and you respond with, yeah, I know everything. Tell us what that means.
Well, prelims is basically a day where you go in, and there's 3 professors, 1 from each course that we took from neuroscience, and it's open-ended. They just can ask you anything from the material that we've covered from that entire year. So, I mean, that is intimidating. You basically have to know everything that you've been taught. So
They don't give you some sort of a list of here are the topics to be covered, or I'll
No.
ask quizzes, nothing like that?
no.
At the very bottom, we see that the defendant references to you another mountain trip. Was that the last hike that we saw you talking about almost a month before?
Yes, that May 6th or that text message, yeah.
Now, he says here, Tony the Tigered. Did you know what that meant?
No, I did not.
Can you go to the top of page, ma'am, 51? And what does he tell you that meant?
Flaked like a joke, yeah.
Tony the Tiger.
Yeah, frosted flakes.
Exactly. Okay, there is... Can you go to page 53, ma'am? Now, this is June the 7th, and you have just exchanged texts talking about each one of you finishing prelims. I want to... You
Yeah.
can take that down for a second, and then I'll have you bring it up in a minute. Where were you in terms of... We've heard already a description that there were 3 professors for 2 different groups, 3 students each. Is that
Yes.
right?
Mhm.
And the group that you were in, which time did you present? First, second, or third? Do you remember?
Oh, I don't remember.
How about this? In terms of you presented when in relation to when the defendant presented? Did you know?
Before. I know that much.
And how do you know that?
Well, because I was done and then asked him what he was obviously in my same group, like the 3 same professors.
I'm doing a horrible job of asking this. Let me just ask you. Did you see the defendant in his prelim presentation that day?
Yes.
Okay.
Yes.
Tell us how that happened.
Because basically there's a room where like a closed door session where the professors are, and then the other students are waiting in another room, before they go in to ask questions, and the next student comes like 10 minutes early or whatever, and then, so there's some interaction.
My guess is you didn't really hear any of the substance of the presentation.
No, you're not allowed to, yeah, and you're not allowed to talk about it with the other students.
But you could see him.
In the room presenting, yeah.
Did he look to you in terms of physical appearance and attire and hygiene any different than he had at any other time that you'd seen him that year?
No.
In his mannerisms and the way he seemed to be answering the questions and presenting, could you detect any difference between that or any of the other presentations you'd ever seen him give?
No.
Okay, ma'am, if you go back up to the top of 53, you then have this conversation about how he perceives that he's done. You recall that?
Yes.
And then, do you think he's joking here about how he's done?
No, it's hard to tell, really.
Okay.
So, it's like an oral exam, and you can write down something, but, yeah.
Okay.
It's hard to tell, and it's intimidating to be in that room.
Did you know when you left whether you'd passed or not?
Yeah,
Did they tell you?
No, but I studied. I knew if I answered the questions correctly or not.
Okay.
So,
54, ma'am. Now we're 4 days later. Now we're at June 11th. And you ask him how he did. And he says no, and then if you'll go down a little bit more, ma'am, he says that he's probably going to quit, and then go down a little bit more. You don't know if he's being serious again?
yeah, I thought he was being sarcastic.
Because
Well, because normally that's not what the PhD program strives for, is to fail out their students the first year. So if you do fail a prelim, you have other opportunities to pass again.
can you get us to 55, the second gray box? And I just want to ask you for clarification on this. He tells you he's quitting Fave Red. Do you know what that means?
I'm assuming it's talking about me. I have red hair, so
Favorite red hair,
I
that
guess
kind of
so,
thing?
yes.
Okay, thank you. And then if you could go to the bottom of that, 55, ma'am, you reach out to him again on July the 8th. almost a month later. And you ask him, hey, are you back in California? Do you recall that?
Yes.
Now, before I get to 56, ma'am, can you take that down? Did you also see the defendant in a setting outside of school other than the hike that you did?
Yes.
Tell us where you would see the defendant.
I'd see him sometimes at the 24-hour fitness, the Lowry 24-hour fitness. That's where I sent this message. The last message kind of it popped my memory, like, oh, where's James? Haven't seen him for a while. Wonder what he's doing, like if he's really quitting, like what's happening.
And when you would see him at the 24-hour fitness, over the spring, you would see him there at the 24-hour fitness?
Yes.
What kind of stuff was he doing there?
Sometimes lifting weights, sometimes, on the elliptical. So I would always initiate the conversation and say hello and, they'd say hi back.
And before I ask you about the text from July the 8th, let me ask you, after the hike, and you'd had that opportunity to have that sort of one-on-one time in the conversations and he dropped you off, was your relationship with him in the hallways or in the school any different than it had been before?
No, it was still more conversational via text, but in person, still kind of shy, and like I would always have to initiate hello and things like that.
Okay. Ma'am, can you get us to the top of 56? You ask him if he's going to California, and he tells you that he's not.
Yes.
And then can you go to page 57? And go down to if you go down a little bit there to, now these are texts that you're sending him from 24-hour fitness?
Yeah.
He texts you this with the question mark there. Have you ever met someone with dysphoric mania? What did you do when you got that text?
It was really obviously we were talking about what you're doing afterwards, so it was kind of out of the blue. I looked it up, like
On your phone?
Smartphones, yeah. So I was looking it up while I was working out.
And did you look at what the described
Yeah.
traits were and whatnot?
Wikipedia.
Well, so it's accurate, sure.
Yeah.
Did you see any of the traits that you read on the phone in the defendant previously?
Objection. Lack of foundation, speculation, improper opinion, hearsay.
Sustained.
Now, can you go to, ma'am, page 58? This is you and go down a little bit, please. Thank you, sorry. You tell him that you've looked it up, ask him if it's manageable, and then you tell him, hey, look, I struggle with some stuff too. What does he tell you?
Yeah, I guess that it was manageable.
Okay.
Apparently not anymore.
59, please. You ask him if he's okay, and he responds with,
Yep.
is that the last communication that you ever have with the defendant is just prior to midnight on July the 8th, 2012?
Yes.
Forgot to ask you about something when you were observing him in class. Did you also have the opportunity over the course of the year to observe his eyes? Pupils?
Oh, always when you're in class, like he was always, looking off somewhere. I do remember a couple times that it just seemed like maybe lack of sleep or something, like they were just really big and like dilated, but I didn't think anything of it. It just...
Over the course of that year, from the time that you first really, not February, because you didn't really interact, but from August of 2011 until the last time that you saw the defendant on June the 7th, 2012, did he seem to you to be in any way, in appearance, demeanor, affect, presentation, at all different?
No.
May I have a moment, Your Honor?
Yes.
Anything else? With the court's permission, could I publish these text messages to the jury, individual copies?
Yes, we can. Do you want to do that right now?
With the course permission, sure.
Yes,
Yes,
let's
sir.
do that. All right, members of the jury, we're going to publish Exhibit P-TR-1046. And we're going to publish it the same way we've done other exhibits. We're going to give each of you a copy, and then we'll retrieve the copies. So if you would give the copies to Ms. Gerlings, please, and then she'll distribute them. Yes.
I'm not sure how long it's permissible for Ms.
Yes. Yes. Mr. Edson and Ms. Spengler, would you approach, please? Okay, the record should reflect that the prosecution has finished publishing People's Exhibit P-TR-1046. Oh, sorry. Now they're done. And please remember, folks, that you'll have an opportunity to review all of the exhibits that have been admitted into evidence. It'll just be one original. You won't have 19 copies the way that we've given them to you now, but during deliberations, you'll have the opportunity to review any exhibit that you wish that has been admitted into evidence. All right, Mr. Brockler?
No further questions, Your Honor.
All right. Ms. Brady, does it make sense to take our morning break before your cross-examination, or do you want to proceed?
I can tell the court it's going to be about 10, 15 minutes.
Okay. All right. I think we better take our morning break. Yeah. All right. Let's take 20 minutes, okay? Actually, let's take 25 because I need to address a couple of things with the lawyers. So please keep in mind all my advisements during the break. Thank you. Please be seated, everyone. And Ms. Allen, you can go on break. Thank you. All right, the record should reflect that the jury has exited the courtroom now. I've had a chance to review People's Exhibit P-TR-347A, and Mr. Edson, I think, is going to mark as a court trial exhibit the modified exhibit the way it was presented earlier today, and then before a few pages are taken out. Mr. Edson, as I understood his comments, has agreed to take out 4 pages from this exhibit. The page that I read into the record, at least I read the beginning of that page, and then the 3 pages that start with testing a system. Is that right, Mr. Edson?
Yes, Your Honor.
Okay. And so, given the modifications that have been made to this exhibit, and I think yesterday it was marked as P-TR-347 without the A, is that correct, Mr. Edson, or was it already a 347A even yesterday before the modifications?
It has always been 347A, Your Honor, and quite frankly, I have not put a formal exhibit sticker on it because I knew we were going through some of these, but that's how it's been referred to.
All right, I'll leave it up to you to determine what type of record for review purposes you want to make and how many of these you want to mark as court trial exhibit. But in an attempt to make the record clear, let me just state that yesterday the people tendered P-TR-347A, and I reviewed it, and after reviewing it, at the end of the day, I expressed some concerns in terms of the defense's hearsay objection. And I said there are things in the exhibit that appear to be admissible, but there are things that appear to be inadmissible pursuant to the hearsay rule, Rule 802. So in light of that, I sustained the objection. This morning, the people tendered a modified version of that exhibit. The people took out some of the contents of the exhibit to address the court's concerns. After reviewing the modified version of the exhibit this morning, I called Mr. Edson and Ms. Spengler to the bench, and we had a conversation. Based on that conversation, the people have agreed to make a second modification to the exhibit by removing 4 pages. The page that starts out with order number 76379, shipment completed. This shipment completes your order. All products have been shipped and should arrive shortly. Dear James Holmes, order number 76379 has been shipped. That page and the rest of that page, I just read the beginning, so the people have agreed to take out that page, as well as the 3 pages that start out with testing a system, and then S32I, that's a Roman or a capital I, remote firing system instructions. Those 3 pages, the people have agreed to take out as well. And so we now have an exhibit that has been modified twice. So does the defense want to be heard anymore with respect to this exhibit as it stands right now, the way it's been modified by the prosecution twice? Ms. Spengler, any other record that you want to make? And I'm not asking you to repeat all your objections. I'm asking if there are any additional objections that you wish to make or anything new that you want to say.
Nothing additional.
Okay, so the objections are, first, to hearsay. And as modified, this exhibit contains only the defendant's statements and in emails and the defendant's school product, school work that he has done, as well as statements of others either responding to the defendant in email or statements from others that the defendant is responding to. And so as constituted, I am admitting the defendant's statements as statements or admissions by a party opponent under Rule 801, and so they're not hearsay. To the extent that there are statements from other people, they're being admitted for the limited purpose of placing the defendant's statements in context and making them intelligible. And so they're not hearsay because they're not being admitted for the truth of the matter asserted. So the objection as to hearsay is overruled. The objection under the Confrontation Clause is overruled because this is not hearsay, number one, and number two, this is not testimonial. The objection as to authenticity is overruled for all the reasons that Mr. Edson stated yesterday on the record, and for all the reasons that I also found that People's Exhibit, what was the exhibit number, Mr. Orman, in which I made the extensive record with respect to authenticity under People versus Glover 2 days ago?
1227.
Was it 1227? Well, Mr. Orman was the one who was up here. That's why I asked Mr. Orman about it.
The note I had, I left in our room, and I trust Mr. Edson to have the correct number. Your Honor.
Okay. Is that your recollection, Ms. Spengler?
It
Okay.
is.
All right. I wasn't sure if it was Ms. Spengler or not who was up here, but now I remember that it was Ms. Spengler. All right. So based on that extensive record that I made, I think 2 days ago with respect to P-TR-1227 and the authenticity of that record, I find that the objection, which is based on the second requirement in People versus Glover, must be overruled. And specifically in People versus Glover, the court addressed the issue of authenticity, and more specific than that, the second requirement, the court indicated that there are 2 requirements. And the second requirement is that because a person may gain access to another person's account by obtaining the user's name and password, the person viewing communications on or from an account profile cannot be certain that the author is in fact the profile owner. That's sort of the second concern of authentication. And the court indicated that in light of these concerns, several, and when I say these concerns, I mean that one that I just read, which is the one at issue right now, and the one about whether you can establish, actually, let me back up. Let me back up because I'm reading from the wrong place in Glover. Okay, here it is. The court in Glover said to properly authenticate the printouts, and these were printouts from Facebook or Facebook communications. The prosecution had to make 2 separate showings. Number one, that the records were those of Facebook, and number two, that the communications recorded therein were made by the defendant. It's the second prong of that test that I'm concerned with here. Clearly, the first prong has been established through the witness the prosecution called. Was it Ms. Covalesi, who testified about the Microsoft emails.
Yeah, Christine Cavalici.
Cavaletti, okay. It is clear that that's established. Now, the issue is with respect to the second prong, and that's the objection, and that is that the communications recorded were made by the defendant. And so with respect to that second prong, the court in Glover explained that the primary authentication issue posed by the admission of Facebook records appears to be the identity of the author of recorded communications. First, because anyone can establish a fictitious profile under any name, the person viewing the profile has no way of knowing whether the profile is legitimate. Second, because a person may gain access to another person's account by obtaining the user's name and password, the person viewing communications on or from an account profile cannot be certain that the author is in fact the profile owner. In light of these concerns, several jurisdictions have concluded that where a message is posted on a social networking website, additional corroborating evidence of authorship is required beyond confirmation that the social networking account is registered to the party purporting to create those messages. And the court cited a case from Massachusetts, Commonwealth versus Purdy, P-U-R-D-Y, where the court said that a message sent from Facebook or from a Facebook account bearing the defendant's name cannot be sufficiently authenticated without additional confirming circumstances. And confirming circumstances is in quotes, indicating that the defendant was the author. The court in Glover then explained that many jurisdictions have articulated a similar requirement for the authentication of other electronic communications, including text messages or emails. And then the court cited some cases after that from other jurisdictions. I couldn't find anything in Colorado that's on point, but I think Glover offers a lot of guidance, and based on Glover, what I'm looking for in terms of the second prong of the test for authenticity is additional corroborating evidence of authorship. And in this case, Mr. Edson made an extensive record yesterday about that, and I agree with him that there is additional corroborating evidence of authorship here, including some of the terms that are used in the emails that were allegedly sent by the defendant, including some of the photographs in here of the defendant, which, by the way, were sent from his other email account, the CU email account, which I have found was authenticated or had additional corroborating evidence of authentication. When I mention the specific language used by the defendant, I'm talking about things like the nicknames that he used for his mother or the nickname that he used for his father, the way he signed off in some of these emails saying cheers, which is a sort of a unique way he signed off on many emails. The fact that some of the emails contain information that is contained within the CU emails. It's the same work product, which apparently is the same because he was transferring or forwarding some of the emails from one account to the other. And so you would expect to find some of the same schoolwork. I said work product, I meant schoolwork, from one email account to the other account, and so it matches. Let me see if I had anything else in here. There is evidence that some of the, although I haven't allowed some of that evidence, in some of those reports, there were reports in here from merchants confirming purchases that there has been evidence in this trial were made by the defendant. That evidence consists not only of receipts that were tied to the defendant's credit card or some other kind of financial type of device or item, but also through surveillance videos that have been introduced into evidence. And so there is evidence that the person who purchased these items was the defendant. And then there is evidence that these confirming emails were sent to the defendant's email address. Again, I have excluded some of those under hearsay grounds, but for purposes of authentication, I have considered them, even though I'm not letting the jury see them. I think that's all I have in my notes. So for all those reasons, the authentication objection is overruled. The next objection is under Rules 401, 402, and 403. I incorporate by reference the lengthy record that I made in admitting Exhibit P-TR-1227 last week on relevance grounds, and also under Rule 403. The same rationale applies here. These are just emails from a different account. That's the only difference, but they're emails, they're communications, and so the same rationale that I expressed for those other emails applies here. And I think these emails are probative, and I find that the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Let me see if I can address then the specific objections that Ms. Spengler made. Ms. Spengler objected to an application for an apartment that the defendant apparently filled out, and an email communication between the defendant and that landlord. As I understand it, this was an application, but it turned out that the defendant ended up agreeing to a lease with someone else, another landlord. But I'm not concerned that this is going to be confusing or that any of the dangers in Rule 403 apply here. I also find that this is relevant for the same reason that all the other emails are relevant. This is within the time frame that I have said is relevant here. It's in April of 2011. So it's as the defendant is moving from San Diego to Colorado. It's related to the defendant's attending school, the defendant's attendance at the University of Colorado here in Colorado. And it's the defendant making preparations for an apartment. So I think it goes to all the issues that are raised by the defendant's plea of not guilty by reason of insanity, as well as the culpable mental state elements required by the offenses charged. Next is the defendant's schoolwork. And the concerns were that there's no grade, that the defendant's just sending it from one email to the other, that it looks sophisticated, but this is there's been no evidence related to neuroscience, and that this is cumulative to other schoolwork. I'm not concerned that there was no grade assigned to this schoolwork. It's not being admitted to show how well the defendant's schoolwork, this particular piece of schoolwork was, how it was graded. It's being introduced for the reasons that I stated, the issues raised by the insanity defense, as well as the culpable mental state elements of the offenses charged. In terms of the fact that he sent it from one email to the other, Ms. Spengler is right that it was sent from one email to another, but there is an objection to authenticity here, so this goes to authenticity. And so if the defense is contesting that these really are emails in Mr. Holmes's email accounts, and that it was Mr. Holmes who sent these emails and received these emails, then this comes in. And I think it's relevant to show that this really was him and not someone else. The fact that it looks sophisticated, but there is no information on neuroscience or some of the concepts described, these are not being introduced to explain those concepts. I talked about this yesterday. And again, if the defense wants me to give an instruction, I will consider it. But frankly, I think we're better off just handling it the way we've handled it. The jury understands that this is not about neuroscience or the specific concepts in neuroscience. The jury gets that the issue here is the insanity defense. That's the primary dispute in this case, if not really the only dispute in this case. And of course, related to that, the culpable mental state elements of the offenses charged. That this is cumulative, yes, it's cumulative. It overlaps with other evidence, and it is to some extent cumulative to other evidence, but it's not the unnecessary presentation of cumulative evidence, and it certainly does not substantially outweigh the probative value of the evidence, because the defense is contesting that it was the defendant who was the author of these emails, that it was the defendant who received and sent these emails. And so I think it goes to that. It goes to show that it was him who was sending emails from one account to the other, from one email account to the other email account. Then I think there was an objection about a May 15, 2012 email that has classwork. And I think the objection was that it's not clear what the assignment was, and that it could be confusing. I'm not concerned about it being confusing because it's not being introduced to show whether the defendant completed this particular assignment properly. It's being, again, introduced to show some of the work the defendant did, which goes to his mental capacity, his cognitive abilities, and whether he had the capacity to distinguish right from wrong, and the capacity to form the culpable mental state requires by the offenses charged. And to the extent that the counsel is concerned about any of this being confusing, that can be addressed in cross-examination or through other witnesses and or in closing arguments. Finally, there's an email about Diablo 3, and Ms. Spengler, I think initially said that there was no reply from the defendant. I think what happened is that the defendant sent an email to, is it blizzard.com? Blizzard.com, and then blizzard.com responds to him. The fact that the defendant doesn't reply after that does not mean that the email exchange is inadmissible. Again, it goes to all the issues that I have talked about, so I'm not concerned that he didn't reply to that email. Next is an email related to the prescription from Dr. Fenton, but that has been taken out, so that has been rendered moot. And then last is the email related to purchases, including Fandango, and the objection was cumulative, that much of this has been admitted through other exhibits, and the people have excised most of these documents now. They've taken them out, not excised the documents, but taken the documents out of the exhibit. Is that from what I see, right, Mr. Edson?
Yes, most all of them, with the exception of ones in which there's specific replies from the defendant.
Right, and as to those, the probative value is the defendant's communication about those receipts or order confirmation notices. It's the defendant's communications that is particularly probative, and I find that that probative value is not substantially outweighed by the danger of the unnecessary presentation of cumulative evidence or about any concerns related to that, so, or any other concerns in Rule 403. I think I have addressed all of the concerns raised by the defense, but if there's something else that I'm missing, Ms. Spengler, you can let me know. Did I miss something?
The court's addressed all of the emails.
Okay. All right, thank you. All right. In terms of Ms. Mosher's testimony, I just wanted to clarify part of my ruling yesterday because I want to make sure that there are no issues and that we, to the extent possible, that we avoid any objections. There was an objection to a string of things that Ms. Mosher is no longer able to do or perhaps has had to learn how to do again, such as holding a spoon or making a sandwich, that kind of thing. I am not prohibiting the prosecution from introducing evidence related to her injuries and the effect those injuries have had in general on her. I think that's fair. So, for example, to the extent that her upper body motor skills have been affected, the people are entitled to present testimony of that. That's part of the injuries that she suffered. To the extent that she has had to relearn some of the daily activities that we all participate in or we all have to undertake, that's fine too. She can testify to that. To the extent that she has been able to learn and been able to do some of those again, but not others, in general, she can say that. What I think is unnecessary is to have her go through and specifically say about making a sandwich, going to the restroom, grabbing a spoon, getting dressed. There was a long list. That's the part that I don't think it's necessary to paint a full picture of what the injuries are. The people are entitled to present evidence of the injuries and to have her testify about the consequences in her life in general as a result of the injuries that she suffered in the shooting. I talked about nerve damage. I also talked about part of her lung having to be removed and the need to use oxygen at night. Those are all consequences of the injuries that she suffered in the shooting. I just don't want the people to get into a list of 20 individual examples of these injuries or consequences of the injuries. Does that make sense?
Yes, Your Honor.
Okay. And I didn't get the sense, by the way, that Mr. Brockler was necessarily intending to go into all those things based on the argument we had. My recollection was that Mr. Brockler specifically was interested in learning to grab a spoon, but wasn't wedded to some of the other things on that list. But regardless, I think what is consistent with Order C-200 is that you present, what's fair is to present a picture of the injuries and without then going into more specifics than that in terms of every single activity that either she cannot do or that she has had to learn to do again. So I wanted to clarify that to avoid to avoid objections, hopefully. If there are objections, obviously make them, and then I'll rule on them as they're made. Is there anything else at this time on behalf of the people?
Just, when are you going to want us back, since you told the jury 25 minutes and we sort of...
Is it okay if we take 10 minutes, or do you folks need more?
That's fine with us.
Is that okay with the defense, or do you need a little more? Fine? Okay, let's plan on us taking about 10, actually, you know what, that's not fair to Ms. Martin and my staff. Let's take 15, and we'll just start a little late, all right? Thank you, the court will be in recess.